Blended learning will be driving change within the educational environment in the next few years, allowing us to extend our reach to the far-flung regions of Quebec. That's why the development of blended learning will be an integral part of the next strategic plan for the college.
That speech was really inspiring, especially the part about blended learning.
I agree. I think that we have no choice but to get on board.
Well, it looks interesting, but I'm not sure I want to commit.
Why is that?
So, you didn't hear the news this morning? One of our colleagues who's been posting content online got a cease and desist order from a publisher demanding that he take down some content he'd posted. It seems there was some copyright issues. I'm all about sharing my course, but I don't want to get sued.
Wow, I didn't think about that. Copyright law is not my strong suit. I hope we can get some help on the legal aspects.
I might be able to help you. During my master's degree in education technology, I had a conference by Master Gilles Langlois from Zuckerberg, Page et Associés that really clarified things for me. It gave me the confidence to start preparing a blended course.
It might be a good idea to speak to a copyright specialist like Master Langlois. Do you have his contact info?
That won't be necessary. You can meet him in person. I noticed that the library invited Master Langlois for a workshop on copyrights this afternoon. I'll be attending to refresh my memory and see if there's any new developments in the province. You can join me if you're available.
That would be awesome. Let's go watch it together. I'll drop by your office after lunch to pick you up. Oops! I better get back to my office. I'm expecting a call.
Good day, my name is Master Gilles Langlois, and I'm a lawyer at Zuckerberg, Page et Associés. I'm also a copyright specialist and research associate at Torvalds University. On today's workshop, we're going to be navigating copyright. Our goal is to allow teachers to make informed choices when using material created by others in their teaching practice. No shortage of ink has been spilled about intellectual property, copyright, digital right management, and lawsuits related to piracy of movies, music, and software. Among educators, there is also some trepidation about appropriate use of media assets, especially within the context of a move towards blending learning. When deciding whether or not to use copyrighted works, as educators, we should always consider the pedagogical or andragogical value of the work we are using. If a copyrighted work is the best resource available, it may be worthwhile to use the resource subject to reprographic contracts and current legislation while paying the associated royalties. New provisions in the Copyright Modernization Act have multiplied the number of protections and taken into account the latest technologies used for transmission of media. Significant measures have been implemented for non-commercial infringers to avoid lawsuits for astronomical and unreasonable damages. The following module presents an overview of copyright in Canada and its importance. The module speaks to recent developments that allow educators and students more flexibility with regards to the use of protected works. Copyright laws exist both to protect creators and their creations, as well as encourage artists to continue their art. It balances the rights of the creators with the rights of the users with protected material. Imagine if George Lucas had immediately released Star Wars into the public domain and didn't charge any fees to see his movie. Would he have had any incentive to create a sequel? Would producers have invested in the project? Would the movie theaters allow people to come to see the movie for free? Would people have thought, it must not be any good if it's free? Would Disney have offered Lucas over $4 billion for Lucasfilm and all its intellectual property? Artistic, dramatic, musical, and literary works are important to our culture. In an ideal world, artisans should be able to make a living from their creativity and be compensated for their contribution to society. In Canada, it is already hard enough to make a living in the arts without speaking of lost revenues from those who do not respect copyright laws. Though for many creators, It's less a question of money and more about the integrity of the work. Some artists have fallen victim to advertising agencies that use their music to hawk the latest wares without permission. With copyright laws, artists have a legal recourse to protect their works from this sort of unauthorized use and be compensated when third parties violate the law. Royalties obtained from licensing rights are an important means of encouraging artists to continue their craft. A copyright is a legal acknowledgement of the right for the creator of content to protect their work, which must be original, in a fixed format, and not merely an idea without form. It allows the copyright holder the sole right to produce, reproduce, or adapt the work. The legislation also specifies the copyright holder's right to authorize others to reproduce the work. In Canada, copyrights are automatically conferred to the author of a work, except under certain circumstances. The copyright for a work generally remains in force for up to 50 calendar years following the death of its author. It should also be mentioned that the author possesses moral rights over the work. It means that the work cannot be altered without the express permission of the owner, but also ensure the author's name must continue to remain associated with the work. In order to have a copyright, our work has to be in a fixed form rather than a mere idea that has not been expressed in an enduring way. This is the first condition to be met. The second is that the work must be original in a non-trivial way. The originality is related to the intellectual effort, skill, and judgment to produce the work according to the findings of Chief Justice McLaughlin in the CCH Canadian Limited versus Law Society of Upper Canada case, which was heard by the Supreme Court of Canada in 2004. The type of work that can be copyrighted fall into four categories: artistic, dramatic, musical, or literary. Each of these categories covers a wide array of media. Here are the definitions of the four categories. Artistic work includes paintings, drawings, maps, charts, plans, photographs, engravings, sculptures, works of artistic craftsmanship, architectural works, and compilations of artistic works. Dramatic work includes any piece for recitation, choreographic work or mime, the scenic arrangement or acting form of which is fixed in writing or otherwise, any cinematographic work, and any compilation of dramatic works. Musical work means any work of music or musical composition, with or without words, and includes any compilation thereof. In addition to books, essays, and other forms of literature, literary work includes tables, computer programs, and compilations of literary works. A note to teachers: that Calvin and Hobbes or Far Side cartoon you have been using in your PowerPoint presentation is protected work for which royalties are due. The Copyright Modernization Act, Bill C-11, received royal assent on June 29, 2012. The Balanced Copyright website at www.balancedcopyright.gc.ca states that, in recognition of the potential that technology offers education, the Copyright Modernization Act greatly expands the ability of teachers and students to make use of new digital technologies and of copyrighted materials for the purpose of education and study. In the summary of Bill C-11, 2 of the 7 reasons invoked for amending the Copyright Act touch education, namely, permit businesses, educators, and libraries to make greater use of copyright material in digital form, and to allow educators and students to make greater use of copyright material. The extension of fair dealing to education was an effort to find a balance between the owner of the work's rights and the interests of its users. The changes to the Copyright Act also sought to be flexible enough to easily incorporate new technologies and other innovations that might replace today's technologies. The Copyright Modernization Act also specified remedies for those that infringe copyrights without any intention of commercial gain for the period leading up to 2012 and the period after 2012 under certain conditions. According to the Balanced Copyright website, Bill C-11 ensures that Canadians are not subject to unreasonable penalties by significantly reducing statutory damages for infringement for non-commercial purposes by individuals, providing the courts with the flexibility to award between $100 and $5,000 in total damages. The bill will ensure that courts take proportionality into account in awarding damages. The Balanced Copyright website gives an example of what would happen for 5 illegally downloaded songs. If found guilty of infringement, an individual will only be liable for a penalty of between $100 and $5,000, and not $100 to $5,000 for each song. The creator of the work maintains the sole right to produce, reproduce, perform, record, publish, translate, or transform the work unless he or she has sold these rights to another party. According to the Copyright Act, if an employee has created a work in the course of his or her employment, the employer is the original copyright holder unless there is an agreement that states otherwise. In the collective agreements of college teachers in Quebec, the teacher who creates a work is reputed to be the author and holds the copyright unless otherwise noted. The royalties for the use of such works belongs to the author unless the college has contributed according to the 2010-2015 collective agreements. Some colleges and universities are now requiring some employees to renounce the moral rights for work created while in the employ of the college or university. Educators should inquire on this topic to avoid any misunderstanding on their rights as the author of the work. The copyright owner can also license or rent their work or authorize a third party to manage owner's right on their behalf. Notwithstanding the copyright holder's rights, there are also important exceptions to copyright for users that fall under a protection called fair dealing. Education was recently added as a new purpose within the 2012 amendments of the Copyright Act. From Section 29 of the Copyright Act, fair dealing for the purpose of research, private study, education, parody, or satire does not infringe copyright. A discussion of fair dealing is beyond the scope of this presentation, but keep in mind that education enjoys an exception to the Copyright Act if the scope of the use of a copyrighted work is fair. The Copyright Act foresees the possibility that an individual or organization enter into an agreement with a collective society that acts on behalf of copyright owners, and that these agreements may differ from the provisions of the law. It is important to note that in Quebec, the Cégeps have signed an agreement with Copybec to facilitate the use of literary works. The current license covers a period from July 1, 2014 to June 30, 2017. Copybec, formerly known as the Société québécoise de gestion collective des droits de reproduction, falls under the category of collective society as defined in the Copyright Act. They offer a licensing scheme for literary works and collect royalties on behalf of the copyright owners that have designated Copybec as their agent. In many cases, Copybec can facilitate the negotiation of rights to use works. Each Cégep that has signed a license with Copybec pays an annual fee of $11 per full-time equivalent student. This allows for teachers to copy up to 15% of the total number of pages for a work, except for works that were specifically developed for the colleges. In this case, teachers can copy the lesser of 10% of the work or 25 pages. An entire article from a periodical or newspaper can be copied provided it does not exceed the lesser of 10% of the work or 25 pages. In order for the owner of a work to receive royalties, the college needs to declare the use of the work so that Copybec knows to pay out the royalty. Copybec maintains a list of creators and their works that are excluded from the license. For more information, visit copybeceducation.ca/en. When in doubt, contact a librarian or copyright specialist to verify whether you can use the content. Collectively, our lives have been greatly enriched due to the abundance of works that have been created by artists. The royalties that these artists receive allow them to work on their next project and advance our culture. As educators, we often employ the works of others within the teaching practice since they have a way of getting a certain principle concept, or message across to our students in a succinct and creative manner. We are just beginning to comprehend what the addition of education as a purpose in fair dealing in 2012 means. Fortunately, the updated Copyright Act also allows for a certain flexibility to evolve as the technology evolves. As we learn, the copyback license continues to provide a means for us to compensate creators for use of their works. Don't forget when planning your lessons or creating your blended learning modules that a number of alternatives to using copyrighted works also exist, such as Creative Commons content or open educational resources. Thank you for attending this workshop. You are now able to make informed choices on copyrights and use it in the teaching practice. Also, don't forget that for more information, you can always consult your librarian or intellectual property specialists.
Well, that shed some light on the subject. It really is interesting. But where do I start?
To make sure that no copyrights are infringed, it's better to contact the library or department responsible for copyright management. Since a copyright is automatically granted, it is sometimes difficult to know if a work is still protected.
It's better to be safe than sorry, especially with copyrighted material. Even for online material, the reprographic reproduction license still applies.